All right, folks, welcome. This is the September 7th, 2023 meeting of the Sentencing Guidelines Commission. I'm Kelly Mitchell, the chair of the commission. I'm going to call us to order, and I will ask Nate to take the roll.
Roll call. Crutchfield?
Here.
Crutchfield here. Fraze?
Here.
Fraze here. Knutson?
Here.
Knutson here. Ladd?
Here.
Ladd here. Larkin? Larkin absent. She did say she'd be running a couple of minutes late. Middlebrook?
Here.
Middlebrook present. Moore?
Present. More present.
Moore present. Morath?
Present.
Morath present. Morin?
Present.
Morin present. Mueller?
Present.
Mueller present. Reeves?
Present.
Reeves present. Saxena?
Present.
Saxena present. Chair Mitchell?
Present.
Chair Mitchell present. Madam Chair, there are a record 12 members present and 1 member absent for the time being.
That is quite the day. All right. In a moment, I'll ask you all to approve the agenda, but we first have a couple of things to get through. Our last meeting was unknowingly the very last meeting of Officer Ibrahim, and so I wanted to take a moment to recognize him. He was able to join us today. And how long did he serve on that?
Just since 2022. So yeah, a little under 2 years.
Right. So Officer Ibrahim served with us for a little under 2 years. Really made some great contributions, especially when we were talking about the new crime of retail, organized retail theft, which I knew nothing about, and he brought some really good insight to the commission on. I just want to thank you for your time here, Officer Ibrahim, and we really value the service that you gave. Do you want to say anything?
Thank you, everybody. It was nice serving in the commission. It's a very diverse pool of a commission of vast experience, and I'm honored to be a part of the commission, and I can say I was a part of the commission and contributed, and thank you again.
Thank you very much. We have a wonderful, certificate for you that Nate will be getting over to you to recognize your time with us. All right.
Thank you, Officer.
Thank you very much.
Thank you.
The Commissioner Schnell is the other outgoing member. He's not. If he shows up, we'll recognize him a little bit later. I'm not sure if he is able to make it today, though, or not. So next item on the agenda then is actually just welcome and introductions. We have some new members. So number one, I just want to say you're kind of all being thrown into the pot with less than a week's notice. So I appreciate everyone who's able to come. And one of our members is online. One of our new members is online right now and won't be able to stay for the whole meeting. But I really appreciate you taking the time to come for as much of the meeting as you were able to. And we will do an orientation for you all. So don't think that this is how we bring new members onto the commission. But Nate will be reaching out about that. Hopefully we'll be doing that. We'll try to do that next month. But I think we should just take a minute and go around and do introductions. So I would just ask everyone to, say your name, where you're from, what position you're representing on the commission, and if there's anything else you want us to know about us. We'll keep it short, but let's just go around the room. So if you wouldn't mind, Latanya, I'll start.
Hello, everyone. My name is Latanya Reeves. I am a career probation officer in Hennepin County, and I represent the probation officers on the commission. And I love working in community and doing a lot of things around public safety.
I'm Richard Fraze. I was a law professor at the University of Minnesota for 44 years. I'm happily retired now, but I spent an awful lot of time as an academic on sentencing issues. So I guess I couldn't leave it behind. So here I am.
Good afternoon, everyone. My name is Brian Mueller. I'm the chief of police for the city of Stillwater. I've been there for a couple of years after about 23 years with Washington County Sheriff's Office. had some time working in groups. I was the chair of the Violent Crime Coordinating Council. Was able to work on some bipartisan forfeiture reform, able to sit on that. And my wife and 5 children live in Stillwater. That's it. I'm representing the peace officer position. I currently sit on the board of the Chiefs of Police Association, but this is not that appointed position, just the lone peace officer position. So thank you for having me. Appreciate it.
I'm Tim Warren. I'm representing the felon with discharge or was discharged from a felony. I've owned my own companies now for 12 years. Done a lot of different community outreach events and different things. Honestly, was approached for this position about a week ago. So first thing I asked was, how am I qualified for this? But here to learn, offer a different perspective, but also still keep a stern representation of what we have for Minnesota State Sentencing as it is. So I'm currently a St. Paul fireman.
You want me to introduce myself?
Sure,
Okay.
yes.
Okay, so I am Nate Wrights. I'm not on the commission. I'm the executive director, so I work for all of you and I run the staff. We've got Jill Payne here representing the staff, but there are other members who are online. I'll get into a little later. We're kind of short staffed, but I've been here 9 years. Before that, I was 15 years in the Rice County Attorney's Office, and before that, I was in the Army JAG Corps as a defense attorney prosecutor. I actually retired from there a few years ago in the reserves, so that's me.
So hi, everyone. I'm Kelly Mitchell, and I'm the chair of the Sentencing Guidelines Commission. Right now, I'm also working at DOC as the Assistant Commissioner of Community Services and Reentry. So I'm occupying the commissioner's seat on the commission right now. And prior to that, I was a researcher at the University of Minnesota.
And prior to that, she was my predecessor, so she had this job.
And prior to that,
And prior to that, I worked at the judicial branch. So there we go.
I'm Catherine Middlebrook, and I am the Chief Appellate Public Defender. So I'm the public defender representative on the commission. Been a public defender for my entire career, as well as doing some teaching at the law schools. I was also at Hennepin County Public Defender's office, but now I've been at the appellate office now for more years than I can count, so.
I'm Brooke Morath. I'm a research tech with the Mayo Clinic by day and victim representative for the commission.
I'm Kyra Ladd. I'm the Wahena County Attorney, and I'm the County Attorney Representative on the commission. I've been the Wahena County Attorney almost 20 years, and I filled Pete Orpit, who was on this commission previously and stepped down. I replaced him to finish his term, and then just recently was reappointed with everybody else.
Hi, Dave Knudsen. I'm a district court judge out of Dakota County. Been on the bench for 19 years. I served 12 years prior to that. While I was a private practice attorney, I served 12 years as a Minnesota State Senator, live in Lakeville, and also on the Minnesota Judicial Council. And I've been on the Guidelines Commission for 2 years, 2.5, 3 years, something like that.
Good afternoon. My name is Chris Crutchfield, and I feel like, I think I have a couple of your books and was in one of your classes in the law school back in the 90s, way back in the day. And I think I was a community administrator when you were at the legislature. And then I worked for Ramsey County Community Corrections for 17 years as a deputy director. And now I am the rehabilitative services rep on this committee. I'm the CEO of Ijama Place, which is a small nonprofit which works with African-American men ages 18 through 30, most of whom have come out of the criminal justice system. I'm very happy to be here.
All right, we'll go online as Surya.
Hey, good afternoon. I'm really happy to join you all and was glad I was able to attend my first meeting. I hope to do the next one in person and meet you all. So my name's Surya Saxena. I'm a partner at the law firm of Green Espel. A lot of my practice is in white-collar criminal defense, and I also represent criminal defendants on the CJA panel in federal court and some in state court. Before that, I was an in-house attorney at United Healthcare for a couple of years. And before that, I was a federal prosecutor at the U.S. Attorney's Office in the District of Minnesota for about almost 10 years. And before that, I was also a defense lawyer at Dorsey and Whitney. So my interest in sentencing has primarily been on the federal side, so I have a lot to learn on the state side. But look forward to working with all of you on the commission. Thank you.
Great, and Justice Moore.
Well, hello, everybody. Gordon Moore here. I try to get to these meetings in person. I'm on the state Supreme Court, and we got on a conference about 20 minutes ago. So Kelly was nice enough to remind me about the Zoom option. I have been a judge for 12 years, or in my 12th year, entering the 4th year here. I was on the district court for about 8.5 years in Nobles County, Minnesota, in far southwest Minnesota, 5th Judicial District. District court judge there. Before that, I was county attorney for 3 terms. I was the Worthington city attorney. I was a lawyer in private practice with the Von Holtum, Malters, and Shepherd Law Office for about 7 or 8 years in Worthington. And I started my work here in St. Paul as an assistant attorney general, doing mostly civil work. I am the appointee of the current Chief Justice, Lori Gilday, to the Sentencing Guidelines Commission. As I'm sure most of you have heard, she's leaving us effective October 1st, and her replacement, I guess, doesn't really want to be on the Sentencing Guidelines Commission. I got the impression that she's going to be reappointing me. So she's got to trust me. She's got enough on her plate. She doesn't need to be doing this job. So I expect I will continue on as her designee after she starts. Natalie Hudson starts as our chief on October 2nd. But I look forward to meeting all our new members in person at the next meeting.
I'm really hurt that you think she wouldn't want to spend her time with us.
No, it's not that. I think she just
There's a lot.
It's a lot. That's 2 jobs basically, and she's going to have a ton on her plate. You know, our current Chief Justice has served for 13 years, and you don't know what you don't know. And I think Justice Hudson is finding out all the things that Chief Justice Gilday did for us every day that, you know, many of us didn't really know about. So, yeah, I think she's very content with me serving on the Guidelines Commission, and I'm looking forward to doing so.
All right. Okay, so for those of you who are new, because we have a hybrid meeting, we have to, the rules require us to do roll call votes, so that we used to be able to vote as yay or nay when it was in person, but the hybrid format requires a roll call vote. So for everything, including approval of the agenda, Nate will have to do a roll call vote. I just wanted to let you know that that's what's up next. So the next item on our agenda is approval of the actual agenda today. So I would entertain a motion to approve the agenda.
So moved.
I heard Commissioner Ladd move, and I saw Commissioner Reeves second. Would you second?
Yes.
All right. So we have a motion and a second. Any discussion on the agenda? Hearing none.
To the Ladd motion to approve the agenda, Crutchfield?
Aye.
Crutchfield, yes. Fraze? Fraze, yes. Knutson?
Aye.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin? Larkin, absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
And with that, the agenda is approved. Next item on the agenda is approval of the draft meeting minutes from July 27th, 2023. These were provided to you a week ago, so you should have all had a chance to review them. I would entertain a motion to approve the minutes. Commissioner Middlebrook makes that motion. Do we have a second?
Second.
Commissioner Knudsen seconds. Any discussion on the minutes? Hearing none, we'll take a vote on that.
To the Middlebrook motion to approve the July 27th meeting minutes, Crutchfield?
Aye.
Crutchfield, yes. Fraze? Praise, yes. Knutson?
Aye.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin? Larkin, absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
And with that, the minutes are approved unanimously. Next item is the fall 2023 calendar, which the whole reason it's on here is totally my fault, and I am so sorry. I wasn't planning beyond summer. I didn't know if I was going to be here. I didn't know how. I forgot to put the October and November meetings on my calendar, and I have other things I have to do on the dates that we chose, or the dates that we chose. So we wanted to address this while Terry is here, so that we can make sure to choose a date that works for the most people. So I'm wondering if it's possible to reschedule October and November. And I'm going to let you figure out how to manage that one.
Yeah, so I did, in the meeting notice, I did ask members to bring their calendars and their dockets and any other schedule things. Typically, we've met on Thursday afternoons. I don't think we need to schedule around Acton meeting rooms availability. We can meet in another place. I think the important thing is that we maximize the number of commissioners who are in attendance. So the issue with November is we can't meet on a holiday, so we can't meet on November 10th. Basically, this calendar has grayed out. If you can see the grays, basically the meeting dates that don't work. I will say historically, the commission's met in the evenings. No, the commission has not done that in a very, very long time, but there's nothing that requires us to meet during the day. But typically we meet Thursday afternoon. So, it would, for example, be fine if we met on October 12th. As far as I'm concerned, I don't know if the afternoon, I'm assuming people have conflicts already, so I don't know exactly how to plan this, but I'll just, I would throw that out there.
I can't do this.
I can't do the 12th.
What about like October 4th? Does that work for anybody? No, okay. Yes.
No.
Madam Chair, are you out the whole week or just that day for that?
For the 5th, you mean? I'm out the 5th and the 6th. Yeah, so other days that week would also work. Like October 2nd, I don't know if that works for people.
And I will say we're planning on having, let me just tell a couple of things about the October meeting, not to, start the party too early, but we did get legislative funding for a comprehensive review of the sentencing guidelines. And we've kind of been waiting to start that until we had the new commission, which we now have a new commission. So I think the chair's intent is to at least begin that process, or begin the beginning of that process at the next meeting. In addition, we were thinking it'd be a good time to have an orientation for new commission members with other commission members welcome to attend as well. Maybe 11:30 that day, maybe provide some lunch and have an orientation before the meeting, have a little break, and then start the regular meeting at 1 o'clock. Just to give you some context there for that. So you're thinking October 2nd is a possibility?
I'm just throwing it out there. Second or 3rd, like, do any other days that week work for anybody? No.
Happens to be, Madam Chairman, the week that I take my annual hiking trip on the North Shore. I will not have Zoom access.
Okay. October 9th. Going once, going twice. Is that bad, Kyra?
Yeah, between my course schedule and then I'm on the executive committee for Todd Whitty and Community Corrections, and we have our monthly meeting that afternoon. So I would be double booked unless, no, I mean.
And I could make that.
Yeah, okay.
Mondays are.
Mondays are hard.
It's Columbus Day.
Oh,
That's federal holiday.
What about the 18th?
Or the 10th and 11th, though.
That's perfect for me.
The 10th and 11th? The 10th, oh, I'm sorry,
The 10th and 11th are bad for me.
the 11th I can't do, but the 10th I could. Those are bad for you?
At
The 18th is
11:30.
perfect though. I think I heard you say the 18th. I don't know what everybody else.
I'm sorry,
The 18th is perfect for me. That works.
18th? Does the 18th work for anybody?
it's okay for me.
I will be out of town at a conference.
You're gonna be out.
I'm the new guy.
I would also be out of town on the 18th.
Gonna lose somebody every no matter what day we do, I think.
Did we eliminate the 12th and the 13th already?
Yeah, I'm gonna be out of town.
Boy.
I'm out on the 13th.
Yep. And then, did we look at 19 or 20?
I'm out of town both those days.
Huh?
Can't do it the night.
That judicial council?
Can we roll it into September?
Huh?
Can we do the last week in September?
Oh.
It's just a thought.
Yeah, yeah. What does that look like for people?
I'm at a conference last week.
At a conference, okay.
Yeah, we have our fall leadership conference at the end of that week. If we go, if I might ask the question back to, when you said sometimes you had evening meetings, if we go back to that first week in October, when you said you're unavailable, are you gone out of town?
For which week?
The first week in October, like for our normal 5th?
Oh, for the 5th and 6th?
I mean, are you just tied up during the day or is it?
For the 5th, I'm tied up in the evening as well, but
Okay.
not the 6th.
6 is perfect for me in the evening. If you're this late.
Friday night?
Fridays are always good for me. I got grandkids.
You know, and actually, I could probably, would people be able to do the 6th if we did like a little bit later in the afternoon?
Which day?
Which day?
The 6th, which is the Friday. Would that work? If we like did it a little bit later than normal, like maybe 2 or 3 instead of 1, would that work for people? I think I could make that work. Yeah, I could make that work.
What time would the orientation be for the new people if you're planning on Friday the 6th?
Well, that is to be determined. I mean, if we need to kick the orientation down the road a little bit, we could.
Okay.
But, or just do a very abbreviated orientation as part of the meeting.
Well, I don't have to be here for that part.
No,
Yeah.
you don't.
If
So,
it
yeah,
works
that's
for
true.
other people to
That's true.
come, you can still do it.
But it works to start the orientation at 2 and then start the meeting at 3, if you want to later in the afternoon.
So,
How long are you thinking for the orientation?
well, we had scheduled an hour and a half, which includes the break, sort of to get readjusted and ready for the meeting, but we could probably squeeze it into an hour.
All right, so let's plan for, well, Surya, would that work for you? What works for you on the 6th?
It would. I have to move something, but I can make that work. So that's why I was asking what time it would start. But I'm confident I could make that.
Okay, so if we did October 6th, no earlier than 2?
Yes, I'm hearing 2 o'clock orientation, 3 o'clock meeting.
That would work for me, if that works for everybody else.
I'm good for the orientation, the meeting, depending on how late it goes. I have an evening conflict, but
How late could it go?
let me back up driving. 4. But I might have some room in that. It's yet to be determined.
Yeah, could we do orientation at 1 instead? Would that work for you, Surya, if we did orientation at 1? if
Yes,
that works.
that would,
I'm fine all day.
that would work. Yep.
How about we do the orientation at 1, meeting at 2? That could get him out of here by 4. Or he'd only miss a little bit. Okay,
So that is, let's see.
I'm so sorry, guys. This is like, you don't know how, I didn't even want to tell Nate I had stuff like this.
I just don't think we can kick off the comprehensive review without the chair, so. I mean, I feel like this is a pretty critical moment in the history of the sentencing guidelines, so. Okay, so we're looking at October 6th at 2 and 3, is that right? Or 1 and 2? 1 and 2, okay.
1 and 2.
All right, and then we have a conflict for November as well?
Yep.
Okay.
Because it's November 2nd, right, is our normal meeting?
It is, and I will say that the reason for that schedule is, let me pop this back up here. So the reason for the schedule is really a technical one. We need 6 weeks in between a meeting and a public hearing due to the meeting rules, which we'll talk about later. And that's to allow for 30 days published notice in the state register, basically. And the math on that works out that we need 6 weeks. So that's why the November meeting is so early. It's November 2nd, because sometimes, honestly, most of the time, we've been needing a December public hearing. And that's typically for a commission initiative, which we'll talk about later as well. We really don't have any commission initiatives that are bubbling up this year, so it's quite likely that we will not need the November meeting to be quite so early this year. So we could definitely bump it a week or two, and it would still be, well, I guess a week would be nice, because it would, well, yeah, even 2 weeks would allow 4 weeks in between the November and December meetings, which is a comfortable space.
So what does it look like for folks if we just look to the next week, the next Thursday, which is the 9th?
That's when I thought it was.
Well, that's a happy accident.
That would be a challenge for me unless it's a little bit later afternoon, like a 2 o'clock start time. I can make that.
If we start at 2.
9th is problematic for me.
It's what?
Problematic for me.
Okay.
Is that whole week, like originally we're the 2nd, so it's the 1st and the 3rd out?
Nope.
Is that the conflict?
The 1st is out, the 3rd is out, yeah. The 1st is not out.
Okay,
I'm
Sorry.
out. I can't.
Okay,
okay.
the 3rd is out. Okay, so the 9th is a challenge for 2 of our members. What about other days that week? The 8th, 10th?
We can't do the
10th is a
10th.
holiday.
10th is a holiday, that's right.
The 8th works, and so does the 6th, but I think
8th
it's
and
Monday
6th.
doesn't work.
That works. I could do actually any other day that week if it works for people.
8th works for me.
The 8th is fine. Maria and Justice Moore. The 8th?
You're saying the 8th?
8th works for me.
I could make the 8th work, Chair Mitchell. I could also do the 9th.
It sounds like the 8th is our lucky number there.
Okay.
All right.
So, I mean, it is an approved meeting calendar, so I think it might be appropriate to have a motion to move the October meeting to October 6th and the November meeting to November. What was 8th?
Second, 8th.
Okay. So if
All right, so I would entertain that motion. Commissioner Fraze makes the motion, Commissioner Knudsen seconds. Any discussion? All right, we'll take a roll call on that.
to the phrase motion to move the October 2023 meeting to October 6th and to move the November 2023 meeting to November 8th. Crutchfield?
Aye.
Crutchfield, yes. Phrase?
Yes.
Phrase, yes. Knudsen?
Aye.
Knudsen, yes. Ladd?
Aye.
Ladd, yes. Larkin? Larkin, absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
All right, with that, the meeting calendar changes are approved. All right. And just to kind of give you a preview too, you know, I'm the chair, but we need a vice chair because sometimes, you know, I might not be able to be here and it'd be good to be able to keep going, or there might be instances where I need to step down as chair for a particular item or something along those lines. So I would like us to talk about that at the next meeting and potentially identify someone who could serve in the role as vice chair at our next meeting. So just giving you, start thinking about that. If you have questions, feel free to reach out and I can talk to you about it. But we'll deal with that. We'll take that up next meeting. And that's it. So now we're going to move on to item number 6, which is recommendations to the legislature.
Thank you, Madam Chair. So if, again, this meeting was not, designed, the agenda was not designed with new members in view. So I apologize if some of this seems like you're kind of coming into the middle of a conversation, because to some extent you are. Although I hope this to some extent is feels a little bit like you can follow what's going on. So this has to do with possible recommendations to the legislature. When I suggested this as an agenda item, I did not suggest this as an action item because I thought, well, the legislature is not meeting until January, so there's no rush on this. However, you may have heard in the news that the governor is considering or is open to the idea, I think was the language, of having a special session in the immediate future. And the recommendations that I'm going to suggest here are, I think, non-controversial enough that it might be possible to just fit them in something else if this were something that the commission were to take action on today. But that would require sort of the consensus among commission members to change this from a discussion item to an action item. So the commission has a statutory mandate from time to time to make recommendations to the legislature regarding changes in the criminal code, criminal procedures, and other aspects of sentencing. And in context, this is in subdivision 6 of the commission's charter statute, which is Minnesota Statute 24409. And the context seems to be in the commission has a research role, and that's mostly staff does that, where we're supposed to be a clearinghouse and information center for sentencing practices and a lot of related issues. And then at the end of that paragraph, it says the commission, that would be you as opposed to staff, has this advisory role to the legislature, where it's actually a mandate that you are required from time to time to make recommendations to the legislature regarding changes in the criminal code, criminal procedures, and other aspects of sentencing. The recommendations that I'm going to suggest here aren't really big policy recommendations that might be sort of what the legislature had in mind. They're really more technical in nature. But let's go over those one at a time. So before we get into those, let me just talk about the status of recent recommendations. So recently, the commission has made some recommendations to the legislature. One of those was technical, to cross-reference the sex trafficking statute and labor trafficking definitions. The legislature heard you, and the legislature implemented those in 2023. The commission also recommended defining the minimum term of imprisonment for murder of an unborn child in the first degree through apparent oversight. There was no defined minimum term of imprisonment. Thankfully, nobody was locked up for that offense alone. I shouldn't say thankfully, because the reason for that is that every time this crime is committed, the mother has also been killed. And so the mother sentence, the sentence where the victim was the mother, really controlled. So, but it is foreseeable that this could be the only offense, and there was no defined minimum term of imprisonment. Now it's been defined, it's treated the same as murder in the first degree. So those are taken care of. What's not taken care of are reconciling age thresholds for prostitution. There's really a typo where they changed the age thresholds, but they missed a spot. And reconciling a statutory violent crime list with first-degree witness tampering. There's an anomaly in the statute where a more severe form of first-degree witness tampering is treated less seriously than a less severe. So it just doesn't make any sense. And the legislature hasn't acted on that. When we talked to the legislature about that in the last session, the impression I got was they're kind of looking at next session as sort of being the fix-it session. And so they might take care of some things then. But as far as new recommendations, so this is sort of not really a new recommendation. It's the one single unfinished piece of business in the first-degree murder of an unborn child recommendation. So there's a pre-sentence investigation statute, 609115, that requires the court to cause a sentencing worksheet to be completed and forwarded to us upon conviction of a defendant's conviction for felony. That's a very important statute for us to do our data role, right? We get all these worksheets, and from those worksheets, we're able to compile those into a data set that the public and policymakers can use. But they also have to send us worksheets when there's a mandatory life sentence. Now, mandatory life sentences are controlled by the sentencing guidelines, but they still have to send us a worksheet so that our data set is complete. So we have all felonies, not just those that are controlled by the sentencing guidelines. And the law has a list of all those mandatory life sentences, but it omits first-degree murder of an unborn child. So you did recommend that that be included. It's really an oversight so that we're sure that we're getting all sentencing worksheets. So that's the staff recommendation is basically keep that one thing that the legislature didn't do with respect to first-degree murder of an unborn child. And I can slow down if you want me to slow down, but otherwise I'll just keep rolling. So the second one is maybe a little more problematic in terms of real-world impact, and that has to do with the 5-year probation cap. So just a little history. So in 2020, you established a presumptive 5-year probation cap in the sentencing guidelines based on some dormant authority that really had been given to the commission back in 1980, or 1978. The commission had authority to establish, but I won't get into that. But anyway, the commission established a presumptive 5-year probation cap with exceptions for listed homicide and sex offenses. So those were not subject to that 5-year presumptive cap. In 2023, the legislature codified this cap. So, and that's really the important thing, is that the legislature changed this into law. But there are 4 differences between the legislature's version of the cap and the commission's version of the cap. First, the legislature added harassment and stalking to the exception list. Second, the 5-year cap is hard. So it's a statutory cap. Whereas before, a judge could impose a longer than 5-year probation term if there were substantial and compelling reasons to justify it. That's no longer true. It's now a hard statutory cap, no more than 5 years of probation for all but these accepted offenses. There's also a change with respect to a couple of offenses with statutory maximums below 5 years. The cap is that the stat max. The cap is the stat max. Formerly 4 years. Okay. Let me back up. So the old rule for low stat max offense felonies, let's say like fleeing a peace officer in a motor vehicle, I think it's like 3 years and a day.
Yeah.
So 3 years and a day stat max for fleeing a peace officer in a motor vehicle. I'll pick on that offense because it's a fairly common offense and it's a fairly low statutory maximum. So before the law changed this year, the maximum period of probation that somebody could get for that is not the statutory maximum, which is sort of the general rule. It's 4 years. So for low stat max offenses, the law provided a 4-year maximum period of probation. So basically any felony was potentially worth at least 4 years of probation, or longer if the stat max was longer. That's what the law was. But the new law provides that the stat max is the maximum period of probation. So going forward for our fleeing a peace officer in a motor vehicle example, that defendant cannot get more than 3 years and a day of probation because the stat max is 3 years and a day. So that's the new law, which is a little interesting because there are some felonies that have statutory maximums below 2 years. Well, the statutory maximum period of probation for a gross misdemeanor is 2 years. So there are some felonies that you can't even get as much probation on now as you can for a gross misdemeanor. Does that make sense? Now, there are two offenses, Crim Sex 5 and criminal vehicular operation resulting in substantial bodily harm, that are on that exception list. And the reason the legislature put them on the exception list is because the way they worded the exception list, offenses that are on the exception list can get at least 4 years of probation. So those are basically the saved offenses that still can get up to 4 years of probation, even though their stat max is maybe less than 4 years. And I know that's pretty complicated, but that's the third change. But and then the fourth difference is that this new cap applies to all current and future sentences with a process for retroactive applicability. So that's something that was not true in the commission's cap. So that's what the legislature did this year. In response, the commission repealed its presumptive 5-year probation cap. So that's gone. So here's the big question. Excuse me. Does the exception list apply to attempts? For example, attempted murder and attempted criminal sexual conduct. Because if it does, then the statutory maximum is the longest period of probation somebody can get for those offenses. But if it doesn't, then those offenses are capped at 5 years, which I think some people might be very surprised to learn. The new statutory exception list does not specify attempts. Okay. So it doesn't say attempts, it just lists all these crimes. It doesn't say and attempts. So a few years back, when the Minnesota Supreme Court was looking at a different statutory offense list, this was in the context of conditional release terms. The law didn't say attempts in that list either. And the Supreme Court said, if it doesn't say attempts, attempts are excluded from the list. Attempts are only on the list if the legislature said it and attempts. So I mean, I'm not saying, but it's possible that the courts may say that attempts are excluded from this list following this Noggle case from 2016. So our question is this is an internal staff question because we organize the sentencing worksheets. The question is, what should a sentencing worksheet say about the maximum length of stay for an attempt, given the fact that there's this confusion? I'll tell you what our answer is we're not saying anything. We're just going to put on the worksheet C609135. But I don't until the courts weigh in, I'm sure not going to be the one to say what the maximum length of stay is for an attempt. But the question for you is, should the commission recommend a statutory change? Is this an unintended possible consequence of the 5-year probation cap, that it doesn't include attempts? So a possible, and this isn't necessarily a recommended change, but a suggested change, the commission might want to consider recommending to the legislature to amend that new list, that statutory exception list, to specify attempts and conspiracies, and also expand it to include offenses that carry life terms, mandatory life terms, which would be murder in the first degree and murder of an unborn child in the first degree. Not those offenses themselves, because you're never going to get put on probation for those offenses, but attempts and conspiracies to violate those offenses. So I know that sounded pretty arcane, and I know that not everybody here has been to law school. So I apologize if that was too deep in the weeds, but I guess to put things in a nutshell, I would go back to that example of the big question: does the exception list apply to attempts? For example, attempted murder and attempted criminal sexual conduct. So the idea here is that if somebody gets convicted of attempted murder or attempted criminal sexual conduct, and they're not sent to prison, but instead put on probation, it appears at least to be a real possibility that that person's maximum length of probation under the current law is 5 years. And that may be considered by some people to be unacceptably short, an unacceptably short hard cap. Not to say that some people, that wouldn't be fine in some cases, but in all cases, that will be the hard cap if this reading of the law is correct. And so it might be something that the commission wishes to change.
All right, so hang on. First, I just want to recognize that Commissioner Larkin has joined us for the record. So welcome.
Thank you. I apologize for being late.
Sorry. And then Commissioner Middlebrook, you had your hand up.
Thank you, Madam Chair. Just to your point on this attempt and conspiracy, in the guidelines provision in 2022, before the legislature put it in the statute, we did not include attempts in the list of exceptions.
So the guidelines provision, I will say true, but the guidelines provision did not include attempts in the list of exceptions. It did talk about, except for attempts it included attempts and conspiracies in the main policy provision, but it's possible that didn't apply to the list of exceptions either. Now, having said that, the guidelines don't view an attempt as like a standalone offense. The guidelines view an attempt as a sentence modifier. Now, Noggle, that case I was talking about from 2016, looked at that and they said, yeah, we know the guidelines consider, they actually, somebody was arguing that in front of them and it said, look, the guidelines don't consider an attempt as a separate offense, it's just a modifier. So by saying these offenses, they're including attempts because it's just a modified version of this offense that's listed. And the Supreme Court rejected that argument because it said, well, the guidelines may say that, but that's not what the statutes say. And this is a statutory list. And the way the statute treats an attempt is it's its own offense, basically. It's not a modified version of that offense. So attempted murder is not just murder modified, but it's its own crime of attempted murder. I mean, it's not necessarily a death when an attempted murder is committed, whereas there's always a death if murder is committed. So it's its own offense separately. So I would say yes, but I'm not sure if that's controlling because of the different way that the statute looks at attempts versus the different way that the guidelines look at attempts.
Anything else? Right. Yes, thank you,
Middlebrook.
Madam Chair. Yeah, I understand what you're saying on that. I do think that the legislature did the statutory provision based on our provision from the guidelines, and so they may very well just use our exception list, with what it seems like.
It does seem that
Yeah.
way. Yes.
Yeah, so in that sense, I looked at the 2022 guidelines and we included it in the provision about that it was limited to 5 years. We included attempts and conspiracies, but we didn't include that in the exception list. So I think that's where the legislature pretty much followed what we had put into the guidelines provision.
Commissioner Ladd?
Thank you, Madam Chair. I think one of the struggles that I have regarding attempts and conspiracies is that how the sentences are actually pronounced, because on conspiracies, they get the full sentence the same as anybody who's doing whatever. So that is a modifier in terms of I'm conspiring to sell drugs versus I actually sold drugs. But if it's an attempt, that sentence is cut in half. So there is a distinction, I think, in those two things. And so I think when we talk about these, any sort of substance about what, if anything, we're going to do, I think we need to recognize that they're not treated the same when they come to dispositions. And that should weigh in on sort of the response on how we approach those things. And I wanted to be clear about that, since I don't think they're in the same bucket.
Madam Chair.
Go ahead, Nate.
So conspiracies are a little odd because there's a different rule for drugs than everything else. So unless I'm mistaken, I think the sentence is cut in half in general. The rule for conspiracies is the same as attempts. But then there's a provision in Chapter 152 that says unless you're talking about a drug conspiracy, in which case the sentence is the same. You don't get a discount for having merely conspired to sell drugs as opposed to actually selling drugs. Whereas you do get a discount if you're conspiring to assault somebody and as opposed to actually assaulting somebody. It's the same cut in half as it would be for an attempted assault.
I think the bulk of our cases, I just want to say, I think the bulk of the cases that we see conspiracies, they come out of 152.
No
I mean,
doubt.
frankly, I've never charged out a conspiracy to do an assault under 609. I mean, those are typically either attempts or completed crimes. So I just want to be clear that when we're having the discussion about attempts and conspiracies, that we keep them separate, because I do think that there are different considerations that should go into that.
Madam Chair.
Commissioner Knudsen.
So, Nate, what's your proposal? Are you proposing that we take a position one way or the other, or can we just send a letter to the legislature and say, hey, take a look at this, we got an issue here and a problem, you need to identify it, is this on the list of exceptions or not? Are these attempts on the list of exceptions or not?
I mean, I guess I was thinking you do a recommendation, because that's sort of your statutory mandate, but I mean, you could just issue flag it. I mean, I could issue flag it. I do that quite a bit, where I'll just write to legislative staff and say, hey, did you see this problem? Without making a recommendation per se.
Yeah, I think the question is whether we would have a recommendation, because it would certainly go faster if we recommended that the legislature change it in a particular way. When we have done that, it tends to go in that way. But I don't know if anyone has any feelings or ideas on what would be the right fix for this. Commissioner Larkin, then Commissioner Crutchfield.
If I'm understanding the discussion, I think we should make a recommendation. We should recommend that these offenses be accepted from the 5-year count.
Okay. Commissioner Crutchfield.
Just to be clear, if we do nothing based on the Supreme Court ruling, then the attempts would be included in the 5-year cap. So doing nothing is actually kind of doing something. Is that correct? Possibly, depending on how the Supreme Court, if we're
Right.
Okay.
That's one interpretation, yes.
Thank you.
Commissioner Reeves.
Thank you, Madam Chair. As a probation officer, whatever we can do to make it very clear for the work that we do would be very helpful. I think the recommendation would be good in this instance. We're right now going through all of our probation cases and trying to get them into court in the next 30 days to be able to discharge them. I currently have one that's been on for several years, 10 plus years for an assault in the first degree. So making it clear, whatever we need to do is make it clear, and I'm fine with making a recommendation. Whatever that recommendation may be from this body.
Commissioner Fraze.
I'm having difficulty, I mean, it's kind of a complex set of issues, but just as a point of information, if attempts are not accepted, so they're subject to a hard 5-year cap, then we're treating attempts and completed crimes similarly there. If there is an exception for attempt, would it be possible for somebody to get a longer probation term for the attempt than for the completed crime? I mean, if you had a 20-year...
Actually, the question, do you have the little paragraph? Because the question is really just about, is the question just about the exceptions?
Yeah.
Yeah.
Right, so the recommendation is so that list that I'm talking about there, 69135 subdivision 2, parens B, that's the new exception list, which is the list for which that 5-year cap does not apply. And what I'm suggesting as a possible recommendation is to specify that the 5-year cap also doesn't apply to attempts and conspiracies to commit those homicides. For the most part, they're all homicide and sex offenses. That's pretty much because the commissioner's correct that this was based off of the guidelines list, and the guidelines attempted to accept pretty much all homicide and sex offenses from the 5-year cap.
So in other words, what you're saying is that a homicide is accepted from the 5-year cap, so you could be placed on probation for 10 years, but because we did not include the attempt would be capped at 5. And the question is whether or not we're comfortable recommending that it stay the way it is with the attempt at something that would be given with the attempt of a crime that would be, if committed, a longer than 5-year probation cap, the attempt capped at 5 years is what you're saying.
I mean, just to be clear. And just
That
as-
was-
That was good. That was good.
I mean, the only non-drug conspiracy I can think of that I was involved in Rice County was somebody who was trying to hire somebody to kill his wife. And so that would be a conspiracy to commit first-degree murder.
There you go.
To illustrate, and that would be subject to the 5-year cap. If my reading, well, I think under current law, it would be subject to the 5-year cap. Is that okay, is really the question here? Or should that be on the exception list and it should be subject to a 20-year cap? Assuming the person's not sent to prison. It would only be if the person's put on probation. Should that probation be limited to 5 years?
And we don't have to decide any of this today. Like, we can marinate on this until next month if you want, and then decide if we want to take action next month.
Yeah, and that would bring me back to my opening statement, is I was only considering this to be something that we put in the report to the legislature that comes out in January at the beginning of actually before the session, because the session's not even starting until February. But then the special session thing came up. And so if this is something that you really think ought to get to the legislature right now, so that they can fix it right now, then now would be the time to take action.
Commissioner Larkin.
I apologize if I missed this part of the discussion. So the offenses we're talking about are presumptive commit offenses, aren't they?
Not all of them.
Most
Most of them.
all of the homicides.
Murders, yeah. So we're talking about people that are supposed to be sent to prison, and if they're getting probation, it's downward departure. And I think what we heard when we adopted the 5-year cap is when it comes to downward departures, judges will be willing to do it if they can have a lengthy period of probation supervision. So that would be one reason to say, okay, if somebody's in for attempted murder and they're going to get probation, not be sent to prison, I think a lot of people in the public would think it's crazy to say probation's capped at 5 years.
And could that possibly affect a judge's decision to downwardly departure?
Absolutely.
The judges said that
They're
when we
not down-
adopted the cap.
Yeah.
They're like, you're
If
going to
they're
get more
stuck with
people.
that, they might just forget that downward departure.
Oh, I'm sorry, Commissioner Mueller, and then Reeves.
I appreciate this conversation, this little piece here. We spent some time on the aid and abet felony murder task force working with that. This is what keys in on me, that there is still holding people accountable. So the community sees that, but there are going to be mitigating factors where whatever those are, where someone has attempted or been part of a conspiracy, pulled in, controlled, whatever that is. And so if I'm hearing from individuals on the bench that this might allow a judge not to incarcerate someone, but to give them probation only if it's an exception above the 5-year cap, I'm definitely in favor of that.
And to that point, are we saying then that if they're on the list, the judge can give them 6 years probation, or is there a determined amount that can go? You said 20 years, but I'm assuming some
Right, and I was.
range in there.
Right, so it would be this, if I may, Madam Chair, so it would be the statutory maximum. So that's always been the upper limit on probation. And I was saying 20 years because the statutory maximum for a life sentence that's divided in half by attempt or conspiracy is 20 years.
I definitely would think that there will be an issue if you don't give discretion on this, that we're going to see more people sent to prison than we would like, just because the judges don't really have an option. I think it's a hard pill to swallow to say 5 years on probation for attempted murder, and especially if whatever involved in planning that is attempted murder. So I definitely think the judges should get some type of discretion in this for that type of crime. So I would definitely like to see this potentially on the exception list, because I would rather them not send them to prison just because they don't have discretion.
Commissioner Ladd.
So just to clarify, but the max for an attempt would be half of, if it was a 20-year sentence for the completed crime, the max for probation would be 10 years because the attempt cuts the sentence, the stat max in half.
Correct.
Right, so just so we're clear on that, it wouldn't be as long as somebody who actually completed the crime, it would be half of that. Yeah.
Good point. All right, so what does the commission want to do? This is a discussion item right now. If people want to turn it into an action item, we can. I can't remember what the process is for that. Or if we want to deal with it next month, we can deal with it next month.
Well, if we can have action, I would make the motion to include attempts and conspiracies to the list so that would make clear that they would be on the list.
To recommend to the legislature.
To recommend to the legislature, correct.
Is that,
Can we do that if it's not on there for action on our agenda? That's my question.
yeah, so if somebody didn't like that, they could bring a point of order,
Okay,
and then you could, I think it takes a 2/3 vote to
get it on the agenda as
get it,
action?
get it on the agenda as an action item, so.
Okay, what, Commissioner Larkin?
And maybe just for the sake of my memory and the new members, it's my understanding that we have a rule that says we don't take action if something hasn't been debated at the last meeting.
On the guidelines, on the guidelines change.
On guidelines. Oh, but this is only
This is not-
legislative. So we
right.
can do it. Okay,
Yeah.
I'm for doing it.
And to be clear, if nobody brings up the point of order, it'll just get passed.
Doesn't matter.
Yeah.
Well, I would second a motion if that's the motion you want to bring.
So has that motion been brought? Is there a motion?
There's
would
a
be my
motion.
motion.
Commissioner
And
Ladd,
to clarify, are you basically making the motion
Yes.
that's up on the screen?
Yes.
and Commissioner Larkin second. And then Commissioner Middlebrook has a comment. We'll open it up for comments.
Okay.
Discussion on the motion.
Thank you, Madam Chair. Actually, I have a question
Yes.
that's not necessarily related to this, but something else that you said, Nate, about some of the felonies, the statutory max is less than 5 years. Does that statutory provision, is it really messy? I mean, do we need to make a recommendation that they need to also clean that up or clear that up?
I don't think it's messy. I mean, it works. It just works like, it reads like a computer code, but it works like computer code too. So it's not plain language, but it's a very functional piece of legislation, in my opinion.
Are you concerned about attempts and conspiracies for that? for
So-
the other
Somewhat
items?
there, but then you also, you have some of these felonies that are, less than 5 years. There's, like you said, there's some that have a 2-year stat max, especially a couple of those new ones that came through. So I was just curious if we should also recommend, if there's something there to clarify, so if they're gonna look at this, they look at all of that and clear it up.
Well, what's your concern there? Because the way that the law reads is that the probation term is the stat max or 5 years, whichever is less. So for most of those offenses, if it's a 2-year stat max, it's a 2-year probation term. And the ones that the legislature was uncomfortable putting in that bucket, they pulled out and moved down to that other paragraph where they wanted the minimum to be 4 years for probation.
Okay, and so that would, I guess that with the attempts in there, that's like a whole nother creature, right?
And
That's what it
so,
is.
so I think what this does, if we add the attempts and conspiracies to the exceptions, then those are the only places where this longer sentence can happen, or this longer probation term can happen. So I think it's okay, because then I think you're still, if you have an attempt of a item that's not an exception, I think it would be covered under the 5-year cap.
If I can just clarify that, Madam Chair.
Yeah.
So the legislature kind of made double duty of the exception list. I'm putting it, where did it go? All right, I'll find it here. But so basically, if an offense is on the list, there's a lot of 69135 references. So if an offense is on the list, the 4-year rule applies to it. So, I don't know why it's not coming up. So, but basically it works like this. If, let's say that there's a 5-year homicide or sex offense, and there probably is, I don't have the statutory maximums all committed to memory, but, so there's a 5-year homicide or sex offense on the list. And let's say that the legislature adopts this recommendation. So the statutory maximum for that offense would be 2.5 years. But because it's on this exception list, right, the attempt is on the exception list, assuming were true, then the court could impose a probation term of up to 4 years, notwithstanding the fact that it's on this exception list. So the 4-year rule would also apply to these offenses, which is really the old rule that applied to all felonies prior to August 1st.
Okay. All right, so I think we have a motion to recommend that the legislature add attempts and conspiracies to the exception list. And we have a second. Do we have any discussion on that motion? And then the two other offenses. Any other discussion on that? Then I will let Nate take the roll when he's ready.
All right, to the LAD motion to apply the 5-year probation cap exception to attempts and conspiracies as suggested by staff. Crutchfield?
Aye.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Knudsen?
Aye.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are a record 13 votes in favor, no votes opposed.
And with that, the motion is approved unanimously.
All right, so moving on to, that was the big one. I don't know why I numbered it number 2, but maybe the idea of finishing up old business.
Commissioner Knudsen.
So now how are you gonna communicate this?
So, yeah, so I would send it out, given the fact that there is a possible legislative session in the works, I would send this out. And if you were to do any other recommendations at this meeting, any other recommendations, I would send it out to the chairs, vice chairs, and minority leads of the House and Senate Credit Committee and their staffs.
Sounds great.
Would you send an explanation? I'm not asking to, I'm asking a clarifying question. Are you just sending the recommendation? Are you sending an explanation with why we're recommending it?
I would put it in context so they understood what the recommendation was trying to do. Yeah.
Right.
All right, so the possible recommendation number 3 is correcting a sentence cap for juvenile.
We don't see it anymore.
Oh, yeah, I'm sorry. Pop it up here. So this is a typo in the law. I think it's a typo. I can't come up with any other explanation for it. And this was pointed out. I got a tip to Karen Jazuski. Karen Jazuski is an attorney for the judicial branch, and she identified this error in the law. So I did not come up with this one. So Minnesota statute 6093455 is basically a big penalty statute for sex offenders, like serious sex offenders is the idea. And some of these actually have required life sentences for certain repeat or heinous sex offenses. And for some of those life sentences, basically I think my shorthand is guidelines to life. So the judge is supposed to pronounce a sentence with a minimum term of imprisonment of whatever the sentencing guidelines recommend and a maximum term of imprisonment of life. So it's almost a return to indeterminate sentencing for these particular sex offenders. The 2020 legislature capped this minimum term of imprisonment for juvenile offenders at the applicable minimum term of imprisonment described in subdivision 4B. But there ain't no subdivision 4B within 6093455. So we've got to assume in the context of the session law, so if you read it in statutory order, it doesn't make any sense. If you read it in the order that the legislature passed the law, it's probably referring to Minnesota statutes 24405 subdivision 4B, which was just passed a couple of paragraphs above it, which establishes the minimum terms that juvenile offenders must serve before being considered for early supervised release. And for those who were on the commission in June and July, you'll recall us talking about this, that juvenile offenders, people who committed serious crimes while juveniles, are now going to be eligible for possible, it's not required, but they'll be looked at for early supervised release as early as 15, 20, or 30 years, depending on how many life sentences they're looking at, how many victims they had, and factors like that. But in no case will a juvenile not be eligible for consideration of release after 30 years. So that's what subdivision 4B said. So it would make sense that the required minimum term of imprisonment for juvenile offenders would be capped at that minimum term of imprisonment described in subdivision 4B. So I maybe it was a little bit tongue in cheek. My recommendation was to amend the reference at the end of Minnesota statute 6093455 subdivision 5 to refer to a subdivision that exists. So if that's 24405 subdivision 4B, which it appears to be, so be it, or something else. But right now it's referring to a non-existent subdivision. So that's the end of that. You know, I don't know if there's an enormous practical impact because you know, those juvenile lifers will be considered for early supervised release, but it definitely, yeah, I'm sure in a particular case it could be a huge deal. So I doubt it's going to come up that often, but there it is. And then we get to possible recommendation number 4, which is to correct the targeted misdemeanor list. And those who were on the commission will remember this, that the legislature added another non-existent offense, 609.749, obscene or harassing telephone calls, to the statutory targeted misdemeanor list. That's the list that has 2 impacts. One is you have to be booked for those offenses. And 2 is if a misdemeanor is on that list, then it potentially counts toward your criminal history score in the sentencing guidelines. But as I said, that offense doesn't exist. There are no misdemeanors in 609.749 that deals with harassment and stalking. And the misdemeanor offense of obscene or harassing telephone calls is found in 609.79. That's probably what the legislature meant to say. The potential staff recommendation, or the staff suggested recommendation, is to reconcile the offense's citation with its name. However, I assume that means dropping off the 9, or dropping off the 4. But
what was number 1 again?
That's
the last one, right?
Yeah, that's the last one. Number 1 was just the record keeping one where they have to send us sentencing worksheets on first degree murder of an unborn child.
Okay.
Like they do for all other legends.
Okay, so 3 and 4 are technical fixes.
I would say 1 is probably a technical.
1 feels technical too, but only we would care.
Yeah.
So I mean, I guess the question is, like, could we do a motion? Would people be willing to just deal with this all at once? These all seem fine to me. So I'm wondering if anyone would want to do a motion to accept staff recommendation on these 3.
I would so move that we.
Commissioner Knutson makes that motion. Do we have a second?
Second.
Commissioner Reeves is the person I saw say it. So Commissioner Reeves seconds. Any other discussion? All right, hearing none.
To the Knutson motion to adopt, or to recommend to the legislature the remaining possible recommendations 1, 3, and 4 as suggested by staff. Crutchfield?
Aye.
Crutchfield, yes. Fraze.
Yes.
Fraze, yes. Knutson.
Aye.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Moran.
Yes.
Moran, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Hexina.
Yes.
Hexina, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 13 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Do you have a comment, Commissioner Middlebrook?
Thank you, Madam Chair. Nate, I just wanted to, on your last comment there, isn't it Appendix 4 that's the guidelines of misdemeanor, targeted misdemeanor list? Because 5 is the new one. Is that right?
Oh, I think you are right. Did I say it wrong? I will definitely fix that.
In that box.
Yeah, you're right. I think I just said it, Appendix 5 on the brain. That was the new appendix. Thank you.
Good catch. All right. Next item is changing Minnesota Rules, Chapter 2000.
All right.
Whenever you're ready.
You know, I was thinking that this is also going to be disorienting, but for new commission members, but it may be in some ways kind of an interesting introduction to how the commission's work works. But maybe getting a little, it's like getting to know a new car by popping the engine and looking at you're popping the hood and looking at the motor. So maybe a little bit too much detail on how the commission's work works, but
Still not up there.
yeah.
Oh, okay.
Just multitasking, which never works. I always try, but. All right, so we're calling this changing the rules for changing the guidelines and decision points. So this is something that the commission has talked about. I think we talked about it in December and we've talked about it since then. But basically, let's talk about the statutory structure and then talk about the rules. So that the statute provides what I'm going to call Category A changes and Category B changes. And this really has to do with the commission's authority to make changes to policy. And some of those, some of those the legislature gives the commission a lot of leeway and a lot of freedom. And others, it gives it a little bit less, but still more than some states, leeway and freedom to make changes to the sentencing guidelines. And it really depends on whether it's on list A or list B. So Category A changes are a little bit less freedom. So those are the changes that amend a grid, a sentencing guidelines grid, including severity levels and criminal history scores, or that result in a change to sentence reduction or early release. So if it results in sentence reduction, early release, changes the severity level, changes the criminal history score, or amends a grid, any of those would be a Category A change, unless the change was mandated or authorized by the legislature in a preceding session. So if it was mandated or authorized by the legislature in a preceding session, that's a big exception. Then it goes over to Category B. So for example, the legislature just created the crime, and we'll say carjacking. The legislature, because that took up a lot of oxygen in their last meeting.
Yeah.
just to pick a crime out of that. So the legislature creates the crime of carjacking, and the commission's going to rank that crime. It's going to assign a severity level to that crime. Well, that changes the severity level, so that would be a Category A change. But because the commission is looking at that in 2023, right after the legislature passed that crime, it moves over to Category B because it was recently it was a change that was, oh, I'm sorry, that's the second exclusion. Changes related to recently created or amended crimes. So because it falls under that second exclusion, it moves over to Category B. So Category B changes are basically everything else, which means a change that's mandated or authorized by the legislature. And sometimes the legislature will do that. They'll say, you need to look at this, or you need to change this. Or it's a change relating to a recently created or amended crime, or any other change that doesn't do any of those things on Category A. It doesn't amend a grid, a severity level, or criminal history score, and it wouldn't result in sentence reduction or early release. So maybe like a smaller change, a technical change or a change that doesn't have those impacts. So here are the two different processes. So category A processes, those have to be submitted to the legislature in advance of a legislative session. So by January 15th of whatever year the commission wants to make the change in, it'll take effect August 1st, but between January 15th and August 1st, the legislature is going to meet. And they'll have the opportunity, if they don't like this change, to pass a law to block it. So that's the process for category A. The legislature can block it before it takes effect. Category B changes, there's no such requirement. So those, there's no amendment process specifically laid out in statute. It just says that the changes will take effect according to the procedural rules of the commission. And it gives the commission rulemaking authority. So the commission has a chapter in the Minnesota rules that we'll talk about in a minute. And that's really the subject of this. What are the procedural rules that the commission has to follow to do those category B changes? Here's the commission's rulemaking mandate. The commission is required to establish rules pursuant to the Administrative Procedures Act. So just to be clear, the sentencing guidelines themselves are not subject to the Administrative Procedures Act, but these rules that you have to follow when you're making changes to the sentencing guidelines are subject to the Administrative Procedures Act. And those are published in Chapter 3000 of the Minnesota Administrative Rules. And the commission did promulgate those rules in 1985. They're basically unchanged since 1985. It's looking at changing them. And this presentation is going to walk through several decision points. So the first just kind of a walkthrough through the rules. And I don't think I included a copy of the rules. Sorry about that. I kind of wasn't really anticipating, wasn't sure whether we'd have a new commission or not. So this is kind of a little bit intended to be review. So part 100 is says that these rules govern promulgation, including guidelines promulgation, including the modification of severity levels of criminal history scores, basically taking that quote right out of the statute. Part 200 is called notice of hearing, and that requires us maintaining a U.S. mail list, a mailing list and formally publishing notice of intent to amend the guidelines 30 days before the public hearing. Honestly, we don't really have a U.S. mailing list. We have an email list, but the rules require us to have a U.S. mailing list. We basically do, but it's empty, I guess. Part 300, conduct of the hearings. It requires participant registration, allows oral comments at the public hearing, written comments for 5 days after, and a second U.S. mail list for those who are interested in the hearing results. So again, we don't have that U.S. mail list, and we publish the hearing results online. So we don't necessarily follow these rules to the letter. Part 400, receipt of written materials, spells out a 5-day written comment period after the hearing's over. So we hear from people, then there's a 5-day written comment period. And then part 500 just defines the elements of the public hearing record. And 600, it has amendment adoption. It requires a majority vote of a quorum present to adopt the proposed amendments. And then we have to, that second U.S. mail list, we mail out notice to folks who are interested about what happened. So
Can I just interject for the benefit of the new people? Why are we even talking about this? As Nate mentioned, our rules were written in the 1980s and haven't changed since then. And they are kind of a clunky system that has resulted in this situation where every year when the legislature is over, we have to put the brakes on everything we've been doing so that we can rank the new crimes. And then we have a very rigid process for how to get public input before those become effective in August. And so it kind of has created this big break in our work every year. So we were talking about whether there's a way that we could still get input and streamline that process. But to do that, we would have to change our rules. So we had general agreement on the commission to relook at what that process is. And then we asked Nate to come back with what are some decision points, places where we could come up with different, feedback that we could give to help him start to maybe do some drafting of what an alternative process might look like. So that's what he's brought to us today, are what are some of those decision points that, could be done differently, that might give us more flexibility in the way we, like, none of this, I just want to reiterate that, like, we do not in any way, shape, or form, we're not trying to prevent any comments from coming in. We're just trying to streamline our process so that we can keep working through the year, and that the legislative session doesn't create such a big break point for us each year. So that's what was kind of happening. Take it away.
Okay, yeah, and the way, I think I pressed the wrong button here, so now I got duplicate screens, so, but I'll fix this. Okay, so, yeah, we ended up, yeah, our June meeting has to be early in June, right after the legislative session is done. And then we have to have a 6-week pause during which we publish the state hearing notice. Then we have the public hearing in sort of mid to late July. And then we have the final hearing, the final meeting right before the August 1st date that the sentencing guidelines go into effect. Sometimes it's like a couple days before. It's a very tight timeline. And it only works if the legislature finishes their work on time. If the legislature goes into special session, which happened a couple of years ago, we're really behind the 8 ball. And we actually had to ask the legislature to make crimes effective September 15th, just to accommodate these rules, basically. So, and the legislature was kind enough to do that, but it kind of seemed like the tail wagging the dog. All right, so the first decision point is notifying the public of the, let me just go through the decision points really quickly. So the first one is, how do we go about notifying the public that there are proposed changes, that there are changes on the docket? The second decision point is, when does that notice go out? The third is, how do we gather public input? And then the decision point 4 is issues related to how we conduct the public hearing. And then the fifth decision point is sort of, should we do more general changes to these rules? And the sixth decision point is, how do we go about doing this? So just to kind of give you an overview of what these 6 different decision points are that we're thinking the commission's going to look at. You don't necessarily have to make these decisions right now. I mean, I guess we could if you wanted to, but this is really more for discussion. And once we do draft these rules, just to reiterate the process, they have to go to the reviser of statutes, who will sort of tell us whether we wrote them right and change them if necessary, and then it has to go through a public hearing process before it's finally adopted. All right, so how do we notify the public of what the proposed changes are? I see 4 possibilities. There's the status quo, the U.S. mail list, and state register publication, which is, it feels a little old-fashioned to me personally, and maybe that's just my bias. I don't know how many people read the state register. Another option is just to kind of bring it up to date, email list and website only. Get rid of the U.S. mail list. We don't actually use the U.S. mail list. The third is kind of a hybrid, do an email list, website, and the state register publication. That's actually what we do right now. And the fourth is to vary the public notice by the type of change. So if it's responding to recent legislation and making technical changes, which is, the recent legislation is when we can come into those time crunches. Jill, is there any way you could make the preview screen in a different corner, so it's not blocking the text? Thank you. When responding to recent legislation, making technical changes, email list and website, because again, you might get in a time crunch there. But for the commission's policy initiatives, take it slow, do the email list, the website, and the state register publication. So you got that 6-week window if the state register actually has any value. And I will say there's also a fee involved in publishing things in the state register for what it's worth. All right, so Madam Chair, I could just roll through these, or if you want to have a discussion at each decision point, that's just fine too.
I think we could stop for each one. Commissioner
I
Larkin?
just have a question. Couldn't it be the case that if you're responding to recent legislation, you are making a policy decision? I mean, when we had to decide where to rank carjacking. So I'm just wondering if you can actually separate
Well,
the decision.
yeah, I guess when I'm saying the commission's policy initiatives, what I mean is as opposed to the legislative policy initiatives. So in some cases, the commission says, hey, we need to make this change. Like it did when it came up with the 5-year presumptive probation cap. That would be a classic example of a commission policy initiative. Whereas in some cases, it's more reactive and it's responding to the legislature. But yes, there's no doubt that the commission makes policy choices when it responds to the legislature.
Commissioner Larkin?
And that's a helpful answer. And I can see why arguably you'd say, well, if it's a policy initiated by this group, you'd use the register because there's no public notice that we're up to this otherwise. But I just wonder how useful it is to use the register, even if there's money, especially if there's money involved.
I have the same question, honestly. Commissioner Crutchfield?
And just falling in line, can you please say more about the state register and the process for posting? Is it immediate? How much does it cost? Can you just tell us about that process?
Sure. So the state register is published every Monday, unless there's a holiday. The deadline for getting in the notices is the Tuesday before. It's in the 3 figures. It ranges between maybe $150 and $300 to do the public notice, depending on how detailed and how lengthy the public notice is. We don't actually put the guidelines changes themselves in the state register. That would get very expensive. We have the rules require us to put in a statement of the notice, the changes, something about the effect of the changes. I can't remember exactly how it's worded, but so we kind of do a quick summary of what the changes are going to be, refer them to the website, which has the complete changes in there. And then, so then it's published. So that's where you get the first 2 weeks are gone, right? So the meeting's on Thursday. The next Tuesday, we put in the order, and the following Monday is when it's published, and that's when the 30-day clock starts ticking. So that brings us to right before the Thursday that's 6 weeks from the first thing.
Commissioner Webb?
Well, I prefaced this comment with my ignorance of maybe some civics that I should know about. So if we migrate away from this state register publication process, are there other commissions or other bodies that have similarly done that have typically utilized that process already and they've migrated and gotten away from what I would say probably is the more clunky process? Or are we sort of on the cutting edge of considering this? I guess I'm trying to figure that out,
So my understanding, and I will tell you that I'm not an expert in administrative procedure, but my understanding is that if you're changing a rule, like Chapter 3000, you have to publish it in the state register. So the legislature was kind enough to exempt the sentencing guidelines from the Administrative Procedures Act. So basically to avoid some of that clunkiness, but the commission has chosen to carry the burden of publishing its changes, or at least a summary of those changes in the state register, so it has similar notice to other rules that are changed. The sentencing guidelines could be thought of as an administrative rule and should be subject to the Administrative Procedures Act. So I think the argument for keeping it in the state register is, hey, this is a rule just like any other rule. It's just because you don't have to follow the same procedures doesn't mean you shouldn't. And so by publishing it in the state register, the legal community is on notice. I know some contracts also go in the state register. I don't have a complete catalog of everything that goes in the state register, but it's kind of like the legal notices section of the newspaper.
Well,
But-
not to be sort of combative, pardon me, Madam Chair, be combative about it, but I just sort of feel like it's like the answer of like, why do we do this? And the answer is, well, because we do it. And not to say that that's wrong, but I sort of feel like it's a good thing to ask ourselves, what are we doing and why are we doing it? And if that's the best way, and if it's accomplishing what it should be accomplishing, whatever that looks like. And so that's why I asked the question about sort of, have we just been checking the box because it's always been the way we've done it, and that's just because answer. And I just don't know that that's an okay answer, and that's why I asked the question.
No, I think that's legitimate, and I think about a corollary would be like how the rules of procedure are notified, what the notice goes out by the court, and that is email and website, and not the state register. I mean, I know that they're not an executive agency, so they're different, potentially subject to different rules, but that seems to work. So I'm not sure if we need to be using the state register. It's going to be adding to our timeline so significantly. Commissioner Tomlin?
More.
More.
And please forgive me if the lack of knowledge on the subject, but is there any other negative implications that are unforeseen, but not what seems like to be the obvious or would be the most logical decision?
I would just say a critic of the commission could potentially spin this as being, a reduction of transparency. I think the counter argument would be, I don't know that anybody who's interested in, I don't know why somebody couldn't just sign up for the email list. If they're interested in the commission's work, they could just sign up for the email list. They get notice and rather than having to leaf through the state register. I don't know. But I guess that would be it. It would be an appearance thing potentially or a spin.
Commissioner Larkin?
Did the legislature pass the rule requiring us to continue to record the videos of the meetings and make them available online?
No.
They did not. Because that would answer that concern that you just raised.
Well,
We're doing that voluntarily, so.
I support
All right, I think you're just asking for sort of some preliminary direction. I think I'm hearing that we email and website might be adequate, and I would say you could look into this question about whether there's really, what is the benefit of the state register? And if there's a benefit to bring back to us, then bring it back to us.
I don't know how I'd research this.
I think we'd have to talk to someone at admin or whatever. Commissioner Reeves?
Thank you, Madam Chair. So I do read the state register. The last one was 40 plus pages. This one was like 20. It is a lot to go through to kind of figure out what you're looking for. So I would definitely advocate for email and website just to make sure that people can find what they're looking for. It is cumbersome to go through those pages to try to figure out if you're trying to look and see what commission business is. So just want to put that. But I do read the register.
That's great. Commissioner Crutchfield?
First of all, I commend you for reading the register. An idea could be that we just put a permanent notice in the register to see the website for changes. Could be, something about referring to our website for updates to the commission. That would be something that we could possibly do.
You have to pay for that though, right?
How much does it cost?
Something so short like that.
Yeah, I've never seen I don't recall ever seeing a bill less than 100, even for the shortest notices. So, yeah, I could defer to Linda if she's on the call, but.
Okay, well, I don't think we have to, let's not worry about that. Let's move on to the next
All right.
decision point.
So the next one has to do with the timeliness of the notice. So the status quo is 30 days before the, says commission action. It's actually 30 days before the public hearing. The commission has to receive, or the public has to receive the notice in the state register. Some other time periods might be, say, 4 weeks, which is the typical time between commission meetings, or a shorter period of time, 3 weeks, 2 weeks, 1 week, or vary the time depending on the type of process or the type of change, or just authorize the commission to establish a time period. And then that would give it some flexibility, say, I'm thinking of a few years ago when we had I think the legislature passed an enormous amount of legislation with respect to criminal sexual conduct on June 30th, if I'm not mistaken. And the normal date when crimes take effect is August 1st. So you got the month of July, basically, to digest everything, bring it in front of the commission, send it to whatever public hearing you're going to have after following whatever notice procedure you're going to have, and then meet and take final action. Now, maybe you could do that in a month if you had the flexibility of deciding it on a case-by-case basis. But as I said, what we did in that case is we asked you asked the legislature to consider making crimes effective September 15th, which is the only time I can remember crimes being effective a different date other than August 1st on a wholesale level.
Thoughts? Commissioner Knudsen.
One of the suggestions here in that slide is can we figure this out in a subcommittee and then that would bring the whole proposal, proposed changes to the commission?
Well, and that's decision point 6 is how are you going to figure this out?
Maybe that should have been decision point 1.
Maybe so. Maybe so.
Are you suggesting that we have a subcommittee?
Yes. And then just focus on it, work through it, and figure out our goal is to have a streamlined, transparent process that we can just operate by. And so what rules do we need to change to ensure that happens?
What do other people, we can jump to decision point 6 right now and talk about that. What are others' thoughts on that?
Yeah, and just to go through this, so the 3 possibilities that I saw, again, not necessarily a complete list, to have a rulemaking subcommittee as Commissioner Knudsen just suggested, which would work between meetings and present their work to the commission. The whole commission collectively drafting during successive meetings, which, that can get tough, but that can be done. And staff drafting between meetings with the commission, refining the staff draft at meetings. Kind of similar to the subcommittee idea, but just having it be staff instead of a commission subcommittee. And obviously staff would support the subcommittee.
Having had a taste of the issues, what do folks think? People want to hash it out here? Do you want to have a subcommittee take a run at it?
If you're looking for consensus, I would support a subcommittee to work on the issue. I think it would be more productive, just in terms of all the different things we're going to be trying to work on here. And I think if we could have something more concise presented to the group for discussion as opposed to the whole deal, that would be my thought.
Okay, Commissioner Larkin.
My thought, if I'm wrong, I'm sorry, is this seems like a whole lot of work to save $100. I mean,
It's not about saving $100.
Oh,
That's just the first. That's just the first question. How we would publish.
how we would publish. Okay, all right. So then everything else.
Yeah,
The
no.
subcommittee, yes.
Okay. Others?
Subcommittee.
I'm not opposed to it. I think that if that's the will of the commission is to have a subcommittee, I think that you could quickly just go through if you want to what the other decision points are, like with very quick, high level, very quick. And then what I'd ask is that if you're interested in being on the subcommittee, please let Nate know, and we can identify that at our next meeting. Mr. Mueller.
Just, I'm in favor of subcommittee too. Is this something, Nate, that staff, I mean, you have an idea on, you guys are the ones that are dealing with this and doing the posting, and you understand the transparency this group needs, and you understand the notification. Is this something that is very easily put together, recommendations by staff to eliminate extra meetings and a subcommittee, or is that the best way to work through this?
I think it would be better if we had some involvement by at least a couple of members of the commission for this particular one. Staff certainly can put something together, but I think it'd be better if we had a couple of commission members.
Thank you.
But just real quickly.
Okay, so decision point 3 has to do with how we're going to gather public input. So right now, the method of public input is a public hearing. So it's a separate standalone meeting. A quorum is not required. People come and present testimony. I will say a lot of those public meetings, public hearings, nobody comes, or 1 or 2 people come if it's not very controversial. We've had some where, dozens of people want to come and talk. So, and then in addition to the hearing part of it, there's also the written part of it. People can provide written comments. And we've had recently, through some email campaigns, we've had thousands of email comments that the commission received recently. So those are the public hearings. So the decision points, should we always use public hearings? Yes, they proved their worth in July 2023. That's where the commission changed its vote on the carjacking proposal based on, it appeared, based on the quantity and comments that were made regarding carjacking. But you could also do less formal comments. That's here on this decision point. Decision point 4 has to do with some issues that are related to public hearings. If you have a public hearing, are there different things that you could do to streamline public hearings? And back to the first one, it's possible that you could just have public input at the same meeting where you make the decision. That would kind of be the most streamlined method. You still get public input, but you don't have to wait a week for the public comment period to close. You can just close it at that meeting and then jump right into action. And then decision point 5 has to do with generally rewriting how big of a bite do you want to take off? Do you want to generally rewrite chapter 3000 to better conform to the plain language standard of rulemaking, or just amend 3000 as it currently exists to kind of tweak the language? I suggested here one possible clarification could be the definition of quorum. There's some ambiguity there. If there's a vacant seat, I'm not really sure whether the quorum, the majority of the members of the commission counts that vacant seat or doesn't. Anyway, so that's a broad overview of the decision points that the subcommittee would be considering.
All right. So as I mentioned, if you're interested, let Nate know that you're interested, and then we can take that up at the next. We can get that subcommittee identified at our next meeting. I think that takes us down to executive director's report.
All right. Well, I have not been this excited about an executive director's report in a long time, Madam Chair.
Will we be?
What'd you say?
I said, will we be?
Well, I don't know. The first thing is, as you know, the legislature funded some of you know that we're really short-staffed right now. We've lost 2 people. One took a job in a different agency. She kind of went back to an old agency that she'd been at. But our senior member who's been with us, a staff member who's been with us since the 80s, retired. Well-deserved, but that left us in a bit of a bind. I've been waiting to fill the backlog until we hired a new position, which is a newly funded senior research analyst supervisor position. So we haven't had a research supervisor. It's kind of been me, but that's not really my background. So I think this is going to be super helpful, especially at this time. This is going to be a key piece of the puzzle to fill in. And then this person will help us hire the remaining backlog. So kind of the idea of the coach gets to pick the team kind of thing. And I'm really delighted to tell you that we're making promising progress in hiring that supervisor. We're going to begin the second interview process tomorrow. So hopefully I'll have some news to share with you regarding that next time. The second thing that I'm just as excited about, so it kind of tickles my bureaucratic heart to tell you that, as we've already alluded to briefly, the legislature in 2023 funded a comprehensive review of the sentencing guidelines. So that's really going to take up a lot of your work in the next, I don't know how many years. And part of that funding included getting some outside assistance in getting high-level research assistance on some of these high-level concepts, research questions that you're surely going to have as part of your comprehensive review. I'm thrilled to tell you about a conversation I had yesterday with Dr. Julia Laskaronsky, who's a research fellow at the Robina Institute. She's presented to the commission in the past, and in 2016, around that time period when the commission was working on the criminal history project, she provided some very interesting research that I think the commission found very useful in working with the criminal history score. And there were some significant changes that came out of that. So she tells me that she is working on a preliminary proposal to Arnold Ventures, which is a national philanthropy that funds criminal justice research, and particularly applied criminal justice research, like when it's going to be used by a policymaking body such as the Minnesota Sentencing Guidelines Commission. That's what Arnold Ventures is really focusing on funding right now. And she is working on a proposal where, with a very impressive team of University of Minnesota scholars that includes Kevin Reitz, who is a nationally recognized expert in sentencing law and a colleague of Professor Fraze here, and Dr. Chris Eugen, who's a well-respected criminologist. And both of these have presented to the commission in the recent past. So some of you may remember those folks. But this team that's going to include Dr. Laskaronsky, Dr. Eugen, and Professor Reitz, no relation, by the way. It is, in addition to probably some students as well, is they're presenting a proposal to Arnold Ventures to basically do free research for the commission on some of these high-level research areas that the commission is going to be looking at. So, from my bureaucratic perspective, and I haven't seen the full proposal yet, or I haven't had a chance to fully review it, but my first impression is that if this proposal is funded, it will give you significantly more research, significantly higher quality research, and at a significantly lower cost to the agency than anything that I had suggested in my request to the legislature. So it stands to significantly assist you in your comprehensive review and at a great bargain to the taxpayers. So I am really excited. Dr. Laskaronsky informs me that Arnold Ventures will likely be deciding in November whether to fund this. The University of Minnesota Scholars team, basically, in assisting the Sentencing Guidelines Commission's work. And potentially this could be a pattern that's followed in the future. I mean, that remains to be seen, and we'll see how this goes. But, other sentencing guidelines commissions do have a pretty formal relationship with their state universities or other universities in their state, leading research institutions. And it would be interesting to see if this goes somewhere in the future. But for now, it really looks promising, even if it doesn't go any farther than this. So but the thing is, Arnold's going to have to know whether the commission supports this. So I am going to ask the chair to put this on the agenda for the October meeting, and basically invite one or all members of this academic research team to make the pitch to the commission on why this will be a workable thing and ask for a resolution of support from the commission on this, if it's something that you feel is worthwhile. So that's coming up on next month's agenda. The last bit of my executive director's report is looking backward. We were able to fund 3 commission members to attend this year's annual conference of the National Association of Sentencing Commissions, which I'm on the board of, by the way, which was held at Lake Tahoe, Nevada, along with 2 staff members, myself and one other. That's all I had. But if any of the commission members who were present at the annual conference this year have any reflections they'd like to share with the group, I think that would be appropriate, Madam Chair, with your permission.
Commissioner Morath, do you have anything you want to share?
I mean, it was my first time attending, and I'll say it was definitely information overload, but in the best possible way. I've been to plenty of conferences through work, and I'll say this one was very different, and I was just really, it was quite apparent, like the level of just willingness to share ideas and experiences was noteworthy to me, and I definitely took a lot away from it. Still processing, still reading supplementary materials that they provided, but for anyone who hasn't attended or is new, highly recommend going.
Great. Commissioner Moore, do you have anything you want to add?
I do, Chair. It was a very worthwhile event, and I'm really grateful for the commission allowing me to attend. I got to be on a panel with a judge from Philadelphia and 2 academics from Villanova and Clemson on sentencing issues related to departures, and it was really interesting to hear perspectives on that. Overall, the company was great. The location was beautiful. I just wished it had been a little longer. It was kind of a quick trip, but it was worth doing. And for the new members to the commission, when your time comes up, definitely say yes.
Yeah, I would say I was the other member that was able to go this year, and there was still a strong theme of review of guidelines, I think, which was really interesting. There was one presentation about a system that's not actually really a guideline system, but Tennessee at one point had like some version of guidelines that got stuck in their statutes and still is there, but they don't really use it. And they had I know it's complicated. Richard and I will disagree on how to classify that state, but there was a Deloitte did some work with Tennessee to help them really like review how their system works and try to consider, whether they want to revive the guidelines or not. And it was really interesting to see that they have like a very structured approach. So they're also people that I'm trying to follow up with as we head into our comprehensive review, because I was really drawn to the way that they thought about how to present information to the public and how to make their system understandable. Those are things that I think we're going to want to really be mindful of. So that was the big thing I came away from from that meeting thinking a lot about, was like how, as we go about our comprehensive review, how do we make sure that we explain that in a way that the public understands what we're doing and actually how the parts of the guidelines fit together and what they mean, and potentially what options as we think about reviewing each policy, what do the different options actually mean? Just thinking about how to communicate that as we go. So that was something I really took away. Do you have reflections? You were there.
I thought the most interesting session I attended was on long sentences and kind of, is there a diminishing return? What are you really getting, between the 21st and the 22nd year of a sentence? Is there, what's the benefit to society? There's no decrease in cost for that year, but, is it is there really something you can measure in terms of the benefit to public for that year? So just something to think about, really the long, and sort of the comment they made is there's kind of a sense of apathy for some of those longer sentences, like, it's easier not to think about. So, I thought that was a challenging session.
All right. Commissioner Knudsen.
Is any of that stuff online or available to the general public?
I know they were talking about it. I haven't looked on the website. It's the NASC.org. So the word the is part of it, and then the acronym. I think it's the NASC.org.
Oh,
But yeah, we have a website. We don't have a staff, so it's kind of run by the board, which thankfully I'm in my last year of, and sometimes the commission's staff, some of the different commissions volunteer their staff to well. So right now Alaska's doing a lot on the website, but
The long sentencing, from that specific discussion, they have resources readily available online, and that's the Council on Criminal Justice. I will say, going back to the most recent public hearing, we had some input regarding the lack of literature out there on victim perceptions, and they have a 2023 recent study that they had conducted, and that's available there as well. So they might be interested in checking that out. Thank you.
Oh, Commissioner Reed.
Thank you, Madam Chair. Do we know when the next conference is?
so the conferences are usually in early August. I don't think next year's date has been set. It's going to be in North Carolina. It's being hosted by North Carolina. Remains to be seen whether it'll be, sometimes they tend to be near the Capitol, which is typically where the commissions are, but North Carolina is aware that they also have an ocean and they have mountains, and maybe the members of NASC would prefer to go there. I will say so I have a spreadsheet, and I basically go down the spreadsheet, and it's the two factors that determine whether I invite you are, well, three factors. One is, are you the chair? Two is, how senior are you and how long has it been? I think the second criterion is how long has it been since you were asked, and how senior are you on the commission? So, if you decline to go when you're asked, it may be a long time before you get asked again. I'll just say that.
All right.
And I should say, and there's no guarantee how many people would be fund in a particular year. It really depends on how our agency budget is looking that year. So
Okay, that's it for your report?
that's it.
All right, so the last item on our agenda is public input. We always leave time at the end of every meeting to allow for public input.
So members of the public, from what I'm seeing, it looks like you are all accessing by computer. So if you would like to speak to the commission, if you have any input you'd like to provide to the commission, please raise your hand. Please indicate that by raising your hand on the computer. There should be a little hand icon. Mine is on the bottom of my screen. And staff, if you're watching this, please raise your hand so I can tell that it's working. Okay, so I'm seeing staff raise their hand. I'm not seeing any members of the public raise their hand. So it appears there's no one online who wishes to provide public input, Madam Chair.
All right. All right, that brings us to the end of our agenda. I, again, just want to say welcome to the new members. We will try to make it less weird next time when you get an actual orientation. And just to preview for all of the rest of you, Nate, we should have said this. We are working on trying to get some information about the comprehensive review to the commission, and if we succeed, we'll start some of that next month as well. We're working with our consultant at MAD on that piece right now. But yeah, so that's what we can look forward to in the months to come. And again, thank you all for coming on very short notice. It was a pleasure to have all of the new members here. I mean, I don't know if it's going to make a difference that we're at 13. That's kind of weird, but we'll call it a lucky number, right? And that's about it. So I'll see you guys next month, October 6th at 1 or 2 p.m., depending on when you're coming. With that, the meeting is adjourned. Thank you.
Nice to meet you. So what-